they plan to terminate the lease because of that. The repairs will take approximately 4 weeks, completed, tested, mold testing, everything. And I'd rather not go to court. I mean, in my opinion, I think that's fairly reasonable given the situation, in their opinion, it's not. If they're willing to go to mediation, what's the best place to go for that?
Are you within the city of Boulder?
City of Boulder, yes.
Oh, these guys.
Give them a brochure.
We can offer mediation for landlords and tenants within the city, if the property is located within the city of Boulder. As far as Boulder County, if you're outside of city limits, the city of Longmont has a program. Oftentimes they're a little bit more flexible in what they can accommodate in terms of if you're outside the city limits. Besides that, if you go to coloradomediation.org, you can find mediators through that website.
I think that's going to pretty much cover it. I'm not sure what the county is doing yet.
And then if they don't want to do mediation, the court is the next step.
Does FEMA have a mediation?
FEMA only does mediation between FEMA and itself, so if you're disputing FEMA and the public, it's that. So FEMA is not provided as a public service to people, but if you are in conflict with FEMA, they have their internal people to deal with if you are questioning a judgment that they've made. This one is kind of a forward-looking question, but I think one that is probably very much on the minds of folks. The situation is we have a landlord with a basement apartment, and the landlord is looking at terminating the lease and remodeling the kitchen, remediating mold, etc. And obviously these are things that will take some time. Is there an ethical or legal obligation to try to re-rent to the tenant at the same rate as before?
I don't think there's a legal obligation if you get us going on ethics. That's a bad way to go. But no, it's up to you. But legally, no.
If the lease is terminated.
Yes.
The paper said the rental rate is, what's it called? 13 years it hasn't been this rented up. There's no place for them to, we could double the rent and still get them to rent. It's the underlying thing. I haven't raised this person's rent for 5 years. She's getting a really good deal. If I remodel the kitchen and do all this upgrading and stuff, can I raise the rent?
Well, if you're
If I
under
just
the
terminate the lease, then I have no obligation.
right, if you don't have a lease anymore, then basically you're creating a new contract, and you can create whatever contract you want.
Here's my question, is she a good tenant?
She's quiet, she pays the rent on time, everything.
There you go.
Yeah.
That has value.
Yeah.
Okay, Ron.
I've got kind of a difficult situation here. I'm actually the agent for a friend who's a landlord. She's financially stretched and has to work 60-hour weeks, and I told her I would help her deal with contractors and whatnot. She owns a 3-bedroom townhouse. She rents the other 2 rooms to help ends meet. One of them was in the basement and is flooded. Unfortunately, it's occupied by a young man who is a little scary. Think James Holmes, scary. He refuses to cooperate with the process, and he's actually screamed at her, screamed at the contractors we tried to bring in. He's sent contractors away. He actually had them remove the fans before things were dry. And so we're in kind of a little bit of a scary situation dealing with this person. We want to get him out as quickly as possible, but the owner is afraid of him and afraid of, retribution and things like that. So what do we do?
Does the man in the basement have an individual lease?
Yes, he's on a separate, my friend owns the unit and rents out 2 rooms in it, and he rents the basement unit, which was damaged in the flood. It includes, there was some sewer backup, and then we've got the drywall and insulation out, but there's exposed wiring. I haven't been able to get a contractor in to look at the hot water heater yet because I'm afraid to have the contractor go in actually. So what do we do here?
Well, I mean, the legal answer frankly is because of the natural disaster or catastrophic situation, your friend can terminate his lease
Her, she,
unilaterally,
okay?
okay? Then the question is, what do you do then? If they don't move, you have to go through the regular eviction process. So there has to be a 3-day notice that says, we terminated your lease and you didn't comply, and then you have to file a judicial eviction, a court eviction, to get him out.
Well, it could be up to 90 days, correct? I mean, if you-
No, like 3 weeks.
3 weeks, okay. What about getting a protection order? Because he has been threatening towards people, including contractors. I've tried to have conversations with him. I get one-word grunts as conversation. I mean, this guy is scary, so.
Whoever asks for the protection order, it's like a restraining order is what I hear you asking about,
Yeah.
is gonna have to satisfy a judge that there really is an immediate danger. And so, one-word grunts won't be enough to satisfy a judge, but if he's actually pushed somebody or threatened somebody in a clear way.
Well, he screamed at contractors.
I don't know if screaming is gonna do it.
Yeah.
And I think it goes a little bit further than that, because it'd have to be, if your objective is to get him out of the basement through a civil protection order, it would, I think, have to be your friend that requested it.
Shoot, I understand that. I'm just saying, we need to get him out so he can do the repairs, but he's not cooperating with any of the process of getting the repairs done. He basically goes and hangs in the room and smokes pot, and
Does your lease have no drugs?
I believe it has a no smoking. I don't know about a no drugs.
I would just give him a notice to vacate,
Okay,
48-hour notice.
48-hour notice.
Sure, if he doesn't leave, then do your 3-day process, demand for compliance, and you may have to go through an eviction.
And you can go to the Colorado Judicial website, and they have a lot of forms and information about doing an eviction, but I think the consensus among all the lawyers is, even though we've been saying stay away from court, this might be one of the times where court is the answer.
It sounds like she does not want to keep him as a tenant.
She wanted to get rid of him before this.
Right, so now she's got a golden opportunity to get rid of the tenant.
Well, he's just gotten scarier as a result.
Yeah, get rid of it.
And he's obstructing work from getting done. I mean, I'm trying to get work done and get contractors in there, and he sends them away, he screams at them, it's crazy.
There's a difference. It sounded to me like you were saying that he's really a threat. If there is a threat or any kind of physical violence issue, that's when you would utilize a protection order, but not for the other purposes.
Should we involve the police in terms of issuing the eviction order?
No, it's a civil process. You have to start with a pre-litigation notice. Once that time has passed, then you file the papers with the court, and then they'll be served with a summons, and then they have to show up in court. And as the other attorneys have said, it's a relatively expeditious process for this very reason.
But you could have the police serve those notices. The sheriff will do that.
Evictions move a lot faster than almost anything else in the court system.
And actually, one side, the last time I looked at the Boulder County Sheriff's website, they said they had taken all their sheriffs off their civil section to do flood stuff, so you can also have a private person serve the summons, and it might be more expedient.
But if it's sewer backed up, can they not say it's uninhabitable and he has to go sewer?
I'm sorry.
Yeah, that's the first
Sewer
step.
backed up.
Because of the casualty.
We can't get the disinfecting done because he won't move out, so.
Yeah.
I think we're kind of going around in circles.
Yeah, we are.
All right, Jeff, Ellie, I also wanted to say, if you had a question and you didn't get on the list, still sign up to ask your question or write it down on a note card and we'll read it for you. Jeff, Elliott?
So fortunately for me, my tenants have been great, and I stepped up for them and paid for all their costs to move out and stored all their stuff and opened my house to them, and that's not my situation. I backed up to a neighbor on my fence property, and although I would have taken in rainwater and groundwater into my property, this other property next to me accumulated tens and thousands of gallons of water, and the only drainage was through my yard. And hence, it ripped through my yard and filled my garage and ruined my new tenant stuff and destroyed my brand new yard. I just re-landscaped 5 days before. Is there any, I'm not asking the other property owners, which is a commercial type property, to pay for my water damage in my property, but do I have any recourse in this situation for them to cover the 3 feet of water through my yard for 3 days that came from their property?
You bring up a very good question, and it would be a civil dispute. And if we didn't have a flood, there's certain rights and responsibilities with regard to drainage and adjacent properties. Since we had a flood, I think that adds another level. And I don't know, folks, do you know in a situation like that if it changes the law?
No, I've even heard stories about, 7th Street becoming a river and people getting out and trying to dam it to divert it down Arapahoe so to go away from their basement and into somebody else's
These
basement.
people didn't do anything to come and help our property. Matter of fact, they didn't show up until they were playing tennis the next sunny day, and I took all their water. I mean,
Yeah, I'm just saying a lot of water went through one property to another and down streets, and it's going to be hard to show that anything was really their fault.
how about that they don't have a drain?
What?
How about they don't have a drain? There's nowhere for the water to go but my property. There's no access to the sewer, the street, anything.
I think you'd have to get a landscape engineer or something. An expert opinion that says it was their fault.
In an ordinary circumstance, there actually is some liability if you allow your property to damage the next door neighbor's property. But you would have to prove a lot of things, as in that they did not follow some building code or something that requires them to drain their water a certain way. In other words, I hate to say it, I'm very sympathetic. I have an abandoned farm up the hill from my house, and the water came down and washed out my dirt road and my driveway. And so, but I have to do it myself. So it's just, you'd have to establish some way that they had a duty.
And they were negligent in performing that duty. They were negligent in handling that problem.
That's my conversation, is I believe they're negligent and that they haven't done proper
I think
due
you're gonna have to have-
diligence to drain their property. And, it wasn't like a little lake, it was 10 feet high, 150 yards long. And it went on for days and days. And I had to trench people's yard.
Well, if there's a significant amount of money involved, it might not be a bad idea just to talk to a real estate attorney to do a little bit more investigation or research. But it might be an uphill battle.
Okay, we're gonna move on. Jean Lavender.
That was me in the bridge.
Oh, okay. Gail Rains.
Okay, I am a tenant, and our carpet, the whole basement was flooded. Utility room, the hallway, the bathroom, and then the big great room that is in the basement and underneath the stairs. The landlord did not come and remove the carpets until it was the 8th day after the flood. The house smelled terribly. During that 8-day period, the power went out for 3 days, and so we left because we had no power. And now they came back and removed the carpet and the padding, and have had 2 fans going since. No communication of what that does or anything like that. Today they came and drilled holes in the drywall and told us that they're going to see how it will turn out, if there's going to be any mold or anything like that. My question is, how long a process do we need to wait? Can we ask for a reduction in rent? The basement is a large part. We had our home office down there. We've had to move upstairs. It was a little crowded. But it is livable at this time, upstairs.
Well, I guess my first thought would be have you talked to the landlord about a reduction in rent?
Not yet, I heard about,
Well, certainly, try, if you want to stay, and it certainly doesn't hurt to try to negotiate something like that. But worst case scenario, if you're not able to negotiate that kind of a situation, you might, and you want to leave, you might, under either the warranty of habitability or constructive eviction, have the opportunity to terminate the lease and get out if you follow the steps that we had talked about earlier.
You may want to call someone expert in mitigation to find out if that's sufficient to take care of the mold or anything else that may be growing. Drilling holes in the sheetrock doesn't sound like that's going to solve any problem.
Doesn't sound like a professional approach.
Right.
Well, and the other thing is frankly, your house was probably uninhabitable 2 weeks ago and you had to leave, but unless you give the landlord a written notice that the house is uninhabitable, the time period for them to fix it or remedy the problem doesn't start running. So
Yeah, get your written notices out to your landlord. You have the sheets on that, so that's the first step.
Can I ask you all about FEMA? Because it seems like from what we've been running into in the office is tenants are able to access FEMA funds, but landlords aren't. We've been kind of encouraging tenants to access those FEMA funds where it's just to kind of reduce everybody's losses and expenses. And I just want to check that out with you all when tenants are looking for rent reduction or a landlord to cover hotel costs. We're kind of telling tenants to access FEMA and just understand that the landlord, just to reduce everybody's expenses. So I wanted to get your take on that.
Yeah, absolutely. One of the concepts in the law is called mitigation of damages. And so if someone is damaged and you're going to be dealing with the landlord in the legal context, and there's some mitigation that could be accomplished by going and getting aid from FEMA, then I definitely encourage that.
Yeah, rather than working with the
Well,
landlord,
both.
or maybe in addition to.
I think you need to do both, but it never hurts.
Well, and I don't know, I'm not sure any of us knows enough about what really is available from FEMA. I mean, or how long it would take to get anything. So, you know, we're telling them to go ahead and apply. I'm hearing from students that they're not getting much help. And I'm hearing from some landlords that students are able to just walk over there and get checks. And I don't know what the truth is. You know, we're telling them to apply, but we're not sure how effective it is.
As a landlord, can I tell them to go get their rent reduction from FEMA?
I think that,
I'm not doing that, but
no, I think that's a really good point.
It's like they're double dipping.
It is like they're double dipping, and the point of the FEMA aid is so they can go out and get other housing. Well, my question is, what happens to the rent that they were supposed to pay to the landlord for the next month? If they're not paying rent to the landlord for the month of October, then they have those resources, financial resources available to use for alternative housing. That's one of the purposes of rent reduction.
Right. FEMA should be there if they're displaced and they're not staying in the property. If they're staying in the property, they're not displaced, so they shouldn't get FEMA. But other than for personal loss that they have.
Right.
Yeah.
All right, we're gonna move along since I don't think any of us have the ultimate answers on FEMA. It would be nice to have one of them here. Ali Brooke?
Right here.
Oh, did you already get your question?
No, that was something about mold I just added to. I have a question about the responsibility of the landlord who is renting to a tenant in a flood zone in a basement. If they have a responsibility to have a drain or sump pumps or anything, because what happened is there's no recourse down there and everything was ruined in 7 inches of water. And there was 4.5 feet of water in front of my door, which we had to bail out to get into the house. And it ruined a lot, as you can imagine. So she didn't have insurance, she didn't have a sump pump, she didn't have any drainage, she had nothing. And she's not, you know, and I lost everything and I went to FEMA, I mean all this stuff, and I went to FEMA and they're not paying and I don't know why yet. Because we are displaced, she gave an eviction
Well, under the warranty of habitability, you know, the landlord is required to provide for adequate waterproofing, weather protection of the property. They're required to comply with all applicable building and health codes. And so depending upon what they did or what they didn't do, it might be in compliance, it might not be. So they might be in violation there.
How would I know?
You have to check the building codes, would probably be the first place to start. If you're talking about like specifically like floor drains, stuff like that.
I think it's maybe a little bit broader scope than just the warranty of habitability, because that just talks about your lease and your possessory rights to the property. I think what you're talking about may be a little bit different, and that is if she's violating a county building code of some kind, and as a result of that violation, the basement flooded and you lost your property, that's a completely different lawsuit. That's what we were talking about earlier with the landlord with the water flooding over, I think it's Mr. Elliott's property. If the landlord didn't do something that we had a duty to do, and you suffered, you know, personal damage from that, then yeah, I think you do have recourse. But it's not necessarily it's not necessarily a leasing issue. It's just more of a civil liabilities issue.
I think it might be just worth mentioning that there's some basements in Boulder that normally don't have any kind of a seepage problem, and people don't have sump pumps there, and there are other basements in Boulder that normally have a seepage problem without a flood, and they have sump pumps going, you know, half the year, whenever the irrigation ditches are full sometimes. So, you know, I'm not sure what the code requirement would be, but some people have them just even homeowners, because it's practical.
I think you'd have to check the applicable building code first and foremost.
What department is that? Is that?
Is it city or county? Well, I mean,
Are you in the city or the county?
Boulder County?
are you in the city limits?
Yeah, oh yeah.
Okay, so that'd be city of Boulder building.
Sorry, Planning and Development Services, 303-441-1880. I have no idea why I can't remember that number.
You're good.
Because nobody is asking about that. That's your general.
Okay, are you good on this question?
Hi, my landlord decided that the basement apartment was uninhabitable, so they gave us the option to leave, and we did. We decided with the landlord what day we would be out, and that day was Thursday. And that was actually confirmed twice. When we got there Thursday morning, they had already had the crews pick up our stuff and put them in bags, and were on their way actually to the dumpster. When I actually stopped them, like physically, like, hey, stop, you know, like, didn't you get the memo? We have until the end of Thursday. So we lost some electronics, basically because they're being thrown around, glassware, some family heirlooms, and yeah, obviously my wife was living, and so, you know, and the point of this is we agreed to be out Thursday night. They started throwing stuff away Thursday morning. And so we want to know what kind of recourse we have as compensation.
How was your agreement? Was it over the phone, a text messages?
It was once in person, and then actually someone else called to confirm that it would be through Thursday.
I mean, the problem you've got is regardless of if there was an agreement, I mean, to actually terminate your lease, even under the warranty of habitability, has to be done in writing, I think, and the landlord. And it actually might help your argument because you still had a right to be in the house. But if you don't have these things in writing, the landlord could say, well, I meant that the lease was terminated Thursday morning at 9 a.m. And you're going to say, no, we agreed to terminate the lease at Thursday night at 10 p.m. But, you know, I guess that's what I'm saying. Is that
Otherwise, you have a claim for damages.
Yeah, my approach would be send them an itemized bill for your damages.
Sure.
And if they refuse to pay it, you can file it in small claims court.
Was it the landlord that removed the stuff, or what?
It was a cleaning crew under direction of them. And what happened actually was that when I told them, hey, stop, they stopped. They said, oh, well, you know, that's fine. We don't need to clean this out right now. They just told us to. So, so then I hear small claims court, and I'm unfamiliar with the fees that I would be paying for that.
Well, you need to know who to sue, so is it the landlord that told him to empty it?
I would sue the landlord, yes.
Okay. You got some way of showing that he's the one that gave the orders to throw your stuff away?
Yes.
Yeah.
To the cleaning company.
Yeah, actually the cleaning crew was really nice about it, and they stopped as soon as they
I would, before you do anything, I'd go get a statement from the cleaning company that said the landlord told us to take these actions at this time.
Okay.
And the other thing is,
A written statement.
yeah, definitely try to send a letter or talk to the landlord before you file a lawsuit, because small claims court can take months. But if you do want to go to small claims court, which sounds like the best way to go, you can go on the Colorado Judicial website. It has a handbook on how to file a small claims action. All the forms are there. You can also go to the clerk, and the clerk over at the Justice Center here will help you put together the
Yeah,
document.
they have a packet that you can pick up.
Right.
It's a pretty speedy process.
Costs are usually less than $100 to get one started.
Yeah.
Okay, one extra detail is that they're going to argue that they did call us ahead of time to let us know. There was a message that we were covered after the fact, and I would argue that okay, you left us a message, but we had confirmed twice with you. We set up a truck that was coming at this specific day, you know, at our expense and things like that. So
Sure.
would that one voicemail negate our claim?
No. It's going to be he said, she said kind of thing, which sort of underlines, you know, in the future, I know it's hindsight, but get things in writing, it truly helps. But try to talk to the landlord, and then this might be a good case for mediation, and try to mediate.
I was going to suggest Clay give her.
Yeah, I might be able to, our program might be able to assist with that.
Actually in the same building.
Could I just add to that? Does it help the case that there's actually at least 20 of us? So we're all from the same complex, and they actually.
Not 20 of you in the same unit.
No, 20 individual units in the same apartment. They came in and threw everyone's belongings, and some of us had statements that said, you have till Saturday, and then others, they said verbally, oh, you know, you're going to have it out tomorrow.
Sure. No, that definitely helps. And one thing that you guys might consider doing is talking to an attorney and who can maybe put together a letter on behalf of all of you.
Yeah, we would like to do that, and if you can suggest to us where we can do that.
Well, the Boulder Bar Association has like a referral service. Do you guys have the number?
Well, actually, in our handout, there is a reference to a website, the State Bar Association. We spoke with the State Bar folks, and I think Karen, you had sent an email to my boss, Karen Ron, about this. The State Bar Association has a free legal advice line that they have set up, and that should be there. And then if it goes beyond the need for specific advice, they could probably do a referral as well. And the person who is running that program for the State Bar Association, we spoke this afternoon, and he encouraged me to let everybody know coming to this meeting that that resource is available to them.
And that's on the third page of the sheet that says tips for landlords and tenants.
Yep.
And then it's on the third page, the last page.
Yeah. So that would be a great resource. I mean, this is the sort of thing, they followed an American Bar Association protocol where they activated this after Irene and Sandy, so it's kind of, that's the level of seriousness that they're treating this with. Moving along to a different topic, let me give you a very specific example here. A tenant is experiencing tremendous pressure from their landlord to empty their apartment of numerous possessions, have kept them working every day along with friends and volunteers. No time to find another place to live. They've needed to be on site to work. They left as soon as the apartment was empty. Yet the landlord doesn't want to prorate rent because I was still living there in technically unlivable circumstances.
It sounds like a constructive eviction where the person vacated the property within a reasonable period of time. And so I think that would probably be a good defense to the claim for that.
Are you saying, I'm not clear, are you saying that the landlord made the tenant do the repairs?
Well, to have forced the tenant to empty the possessions, which for them was an extremely challenging circumstance because of a lot of things and the ability to sort of get people to help out, etc. So the time frame, I believe, was extraordinarily tight, and just the capability of one person to do this with some support from friends was extremely challenging.
And it wasn't repairs at all.
Right. It was getting stuff out.
Yeah, there should be some adjustment on the rent There's also perhaps a security deposit issue that may come in later. So these are remedies that you can have in small claims court if things do not come your way.
Okay.
They were willing to give me my security deposit until I declined to sign the waiver of liability that they started.
Yeah. Because underlying all this warranty of habitability stuff and all this, the issue of security deposits, and that's probably holding the panel.
But as a general matter, I mean, frankly, if you're getting agreements that say waiver of your rights or waiver of your ability to do something, do not sign it until you have a lawyer look at it.
A lot of those aren't enforceable anyway.
Right, but I
As
would
we like
rather
to-
not, yeah.
The security deposit.
And I do have just kind of in a similar vein, probably easier to answer question. If landlord decides to terminate the lease, do they have to give the tenant 3-day notice to move out belongings? And can they get their security deposit back?
Okay, if the landlord terminates the lease?
Yeah, if landlord decides to terminate the lease, do they have to give 3-day notice? 30, oh, excuse me, looked like 3, sorry. 30-day notice to move out belongings.
So it normally would be a shorter time than that. That's something that the landlord does. And usually they would return the security deposit at that time and prorate the rent. I've seen it where they give that 48 hours notice on that, not 30 days.
Okay, when there's that sort of, okay.
Right, and just sort of backing up, if we weren't dealing with a tragedy or a catastrophe, then under the law, and you were affecting a notice to vacate, you'd have to give a written notice, and it's a 3-day notice, but not 30 days.
Okay.
Thank you.
Eric Foxer.
Yeah, I have a lease with a clause that states the landlord may not withhold rent pending, the tenant may not withhold rent, given that the landlord's obligation to repair the premise is separate from the resident's obligation to pay rent. And furthermore, the resident may not withhold payment of rent pending repair or replacement or improvements to the premises. How would this affect my ability to argue for rent reduction for the period of uninhabitability?
Well, they're trying to get rid of the mutuality of obligations there, and that is enforceable. There's a case in Colorado that says it is. So in answer to your question, it wouldn't allow you to withhold rent, but under the warranty of habitability, you could certainly seek a reduction of the rent as damages against the landlord, or as a defense if the landlord was trying to go after you for the full amount. That would be my reading.
Yeah, but I guess the other thing, and I'm not sure about your situation, are you actually not living there because it's uninhabitable and they're wanting you to pay rent anyway?
Correct.
Yeah, no, I think that's a different situation. If it's completely unlivable because of the conditions and you're outside the apartment or house, then I think you're entitled not to be required to pay rent while the place is unlivable. I think what you read was a clause that's usually there because a lot of tenants coming here from other states are used to being able to make repairs on plumbing and then deduct that from the next month's rent and give the landlord the bill they paid for the plumber, but that won't work in Colorado. So Colorado's law is whether or not you make repairs to the place, you pay full rent. But I don't think that clause was designed for this situation.
So are you out of there permanently now, or what's your situation? I guess I didn't know.
No, it's probably temporary. But what you're saying is the landlord is not allowed.
If it's temporary, my read would be that you'd still have to pay rent.
So we'd have to pay rent for October even though our place is uninhabitable still?
Well, you know, I think maybe there's more of a practical solution issue to that, and that is what happens if you don't pay October rent.
Yeah.
You're going to get evicted. You're going to get a 3-day notice, and the landlord's going to say, you didn't pay rent, and so I'm going to evict you. And you're going to end up in court fighting that battle.
But the property is uninhabitable.
Right.
Well, let me back up a little bit. First of all, if you're in the same spot or something, did you give written notice that the place was uninhabitable?
No, because they want to move back in.
We want to move back in, but
Well-
she's not willing to compromise on the rent. She expects us to pay full rent for all of September and all of October. We don't even have a time frame of when the place will be habitable.
Well, the conservative answer that I would give you is to pay the rent, and then you have a right to go after the landlord to receive that rent back as a claim. That would be cover all your bases. If you wanted to be a little bit more reckless, you could withhold rent, not do it, but then you're might end up in court and then have to use that as a defense or a counterclaim. So the best thing to do would be to try to talk to the landlord and say, hey, we ain't living there, can you abate the rent? Otherwise, we're gonna have a claim for damages against you for that amount. And we have an attorney's fees clause in the lease, and we don't wanna go that way. We'd like to work out a deal with you.
It sounds to me like you might want to talk to Mr. Funk again about mediation, because my guess is your landlord probably isn't here tonight and doesn't know what you know now.
Yeah.
Maybe process of educating your landlord as to what the rights and obligations are regarding possession and rent.
And I feel you guys, because you're saying, hey, we're not in there, why should we have to pay rent? So I see, you know, I feel.
None of our stuff is there.
None of it? Do you guys want to get the heck out of there?
Well, I need to mention something, because a lot of people don't want to leave or would like to move back, but there comes a time when you have to, when they say habitability, they mean, can you live there? And if you can't live there, you have to leave. I know that sounds hard, but if you don't give the notice now, thinking that it might get fixed in a couple of weeks or 4 weeks or something, you're not going to be able to proceed with the warranty of habitability as backup or as protection in case you don't move back in. And you have to assert that the place is uninhabitable and that they need to make the repairs. Because this could go on for weeks, months, and it's true, you can't withhold rent in Colorado, so you're going to have to pay the rent and ask for a rebate, but it's going to be tough.
In other words, get out your notices.
The reason why we didn't, well, why I didn't write that letter was because she said it would be 2 weeks and then we can move back in. And now today is actually the day that we, according to her, can move back in.
So she's wanting you to move back in now?
She wants us to stay there. She wants us to move back in, but.
But not yet?
Yes. But even though previously she said today would be the day that we would move back.
So she said 2 weeks.
From the day we had to move out.
Right, and so today is the last of the 2 weeks, and it's still not ready for you to move into?
Yes.
Okay.
So how much longer do you think it'll be?
Well.
You don't want to let it go on forever,
No.
right?
But there's nowhere else to rent.
Okay.
Right, and so in that case, then I guess what you're looking at, you're paying the rent to preserve your right to go back in the property and hold on to that property. And if that's valuable to you, then that might be a reason to continue to pay the rent. And if not, then, you know, maybe the best thing to do is to terminate the lease and try to go somewhere else.
Yeah, I agree with the notice, what Karen said about sending out the notices now. That also may be a tool that you can use to negotiate a resolution with the landlord. Specifically, if she doesn't know that you have these rights under the warranty of habitability and you send out that notice and suddenly she says, oh, gosh, I didn't realize you had that right to do that. Maybe we should talk.
The other thing it does, frankly, is if you give them the 5 working days, it gives them a deadline to get the repairs done, which if it had been done a little while ago, the deadline may have been met now. So I'm just saying it's not too late to do it, but you know, you could be looking at next month, it's still not repaired, and then saying, I wish I had done the notice. So
The way I read it, giving the notice does not require you to terminate.
No.
You can still have second thoughts and say, well, you know, I guess I've decided.
Use the first document in the package.
Unless the landlord makes the repairs in those 5 days. But that's what you're after, right? And if the landlord doesn't make the repairs in those 5 days, then I think we would agree that there's an